thank you, and thank you for joining me today. Brenda and I did a little bit of brainstorming about what to do for this year's presentation, and we decided that asset protection for weird assets would be the overall theme of the day. And I volunteered to talk about asset protection for retirement benefits for two reasons. First of all, it's important for many, many people. It's a major part of their retirement. And the second reason is it's really, really complicated, and this gave me a reason to bone up on all the legal technical stuff. So the other thing is what you may or may not know is that, yes, I've been doing estate planning for a long time, but before that I started my life as a bankruptcy attorney. And so I think I have some kind of sense of what asset protection really involves, and I'm hoping that this discussion will be helpful to you for that. We care about asset protection for our clients, both for the retirement benefits and just in the general broad spectrum, because we want to help them. Most people work hard for what they have, and they want to be able to protect it in case some kind of misfortune happens. And it doesn't necessarily have to mean a lawsuit. Brad Erdosi is here to talk today about asset protection in case you have a catastrophic illness with all of the expenses that come with that. And then it can help ourselves. You know, if we are able to help our clients keep their stuff, the financial advisors in the room have more assets under management. That's sort of a certain amount of self-interest, but that's okay. If we can help our clients, we can help get ourselves out of trouble by avoiding advising people incorrectly or seeing a possibility and also advising knowing when to tell our clients to go see somebody to help them. And then hopefully this might be useful to you too if you have some concerns about preserving your wealth. I thought I would start today by giving you a primer on what asset protection is, and then a primer on retirement benefits, and then weave them together. I am hoping that I don't insult anybody if it gets a little bit too basic. I got a smile or two. If I am insulting you, let me know and I will move on. Okay. There's really, no. Back. No, that one. Thank you. The how. Actually, no. I want the why slide. I'm sorry. Why do we do asset protection? The first and most obvious is that not everyone manages their life well. How many of you know a 19-year-old that manages their money well? Yeah, and how many of you know a 19-year-old who doesn't manage their money well? Right, okay. And especially in my life as a bankruptcy lawyer, what I have learned is there are some people that never manage their lives well. For whatever reason, it just doesn't work for them. And so we want to put structures in place so that even though they can't do it, many parents want to make sure that their kids have a safety net. That's one reason for doing asset protection. Another reason is creditors and predators. We can get in trouble for whatever reason, and we're sort of pulling ourselves out of the Great Recession. And we've seen a number of people get in trouble, and they've gotten in trouble, A, because maybe they weren't quite as rigorous about managing their finances as they might have been, or they lost their jobs. It really had nothing to do with them, and they're suddenly finding themselves with some bills that it's very, very hard for them to pay. And then there are the predators, as we call them in the estate planning world, the people that sort of take advantage of people who don't necessarily have the appropriate knowledge that they need to manage their affairs. And we have CPAs in the room, so you're aware of the IRS's dirty dozen for tax scams. We all know people that have fallen for investment advice that just is too good to be true. And then the predators might also be that child-in-law who you just really don't like, but who your kid insisted on marrying anyway. So there are people who take advantage of people for whatever reason. Then things happen, you know? You can get in an automobile accident, you can get sick, stuff happens that doesn't have anything to do with managing your life, not managing your life, it just happens. But that can produce claims against you and maybe a threat to your nest egg. And it's litigious out there. Our legal system is such that anybody can sue anybody for anything. They may not win, but it is a pain and it's expensive to defend the lawsuit. So Asset protection is a way of protecting your nest egg, but it's also a way of making it really hard for the creditors out there. And that's kind of the point of my primer as far as what asset protection is that even if there is a claim against you, you make it tough for people, and so that they give up, they settle with you rather than going full bore against you, because they know it's just going to be so hard to get at your stuff. Okay, next slide. When? When do you do asset protection? Hopefully you do it when things are copacetic. When the client comes to you and they say, yeah, life is good, we're making some money, and you say, great, now tell me a little bit about what you own. And they say, well, I have the 5-unit apartment building down the street. And you go, oh dear, oh my goodness. And they say, yeah, and I inherited the gas station from my dad, and we've raised it, and we've put a dry cleaner on top of that. And you're thinking, oh my God, environmental liability. And they say, I've got a 16-year-old, and they just got their driver's license. And you're thinking, oh my God, he's a nice kid, but he's 16. You want to do the asset protection then, when there aren't any claims on the horizon. Before you discover that your tenant is running a crystal meth lab in the kitchen of your rental unit, before the EPA swoops down on your gas station, and before your kid gets in an automobile accident. And so that is the time to do the planning. If somebody comes to you and says, yeah, I got all this stuff and life's good, but I got served with a lawsuit yesterday, it's probably too late. And at that point, I would suggest that you talk to the really aggressive asset protection planners out there. And Brenda and I know a couple if it gets there, but it's usually too late after the claim has arisen, because there's something called fraudulent conveyance statutes. And these things go back to the time of Queen Elizabeth I. And basically, if you transfer transfer assets with the intent to hinder, delay, and defraud your creditors, those transfers can be set aside as far as that creditor goes, and you can incur liability as a result of it. And so, the classic fraudulent conveyance is you get served with a lawsuit and you say, my brother-in-law's a good guy, I'm just going to give all my stuff to him. No, those can be set aside. A very classic fraudulent conveyance is, I'm just going to put it all in my spouse's name. And in some states that might work, but in California, we're a community property state, your spouse owns half of it anyway, it's not going to make any difference. But those transfers can be set aside, and if you're not in bankruptcy, the creditor that you're trying to avoid can undo them. If you are in bankruptcy, the bankruptcy trustee can undo them. And there are criminal penalties for engaging in fraudulent conveyances. You can spend 5 years in jail under California law and under federal law. Another thing is if you're looking at a bankruptcy and you engage in fraudulent conveyances before you file for bankruptcy, you can lose your discharge, which means you go through bankruptcy, you lose everything, but you don't get any of the relief that goes with it. So this will not happen to any of you, but it might happen to some of your clients. And so hopefully you can do a little bit of issue spotting of when to do it and when not to do it. The next slide is the how. And the first how, next one, that one, you were perfect. The first how is what we call exemption planning. And I will weave these together as we go along. What does this have to do with retirement benefits? We don't have debtor's prison here in California. Apparently in Colorado, if you're really mad at somebody owes money to you, you can have them put in jail as long as you pay for their incarceration expenses. I'm not making this up, although I haven't checked the statute recently. In California, we do not authorize that. And the laws provide people who owe money, who are in financial trouble, who are going through bankruptcy, to keep certain property. It is called their exempt property, and it's designed so that they don't wind up on the street, that the people who owe money can continue to feed their family, that they continue to earn a living and maybe pay off your debt. And these exemptions apply before you're in bankruptcy. Let's say you just have one claim against you, or if you file a bankruptcy, or if your client files a bankruptcy. The law allows you to keep some of your stuff. I can tell you that California is not a particularly debtor-friendly state. I'm sure you've heard, I mean, the best example I know of somebody who was in financial trouble and did just fine was O.J. Simpson until he got in a little bit more trouble and he's now in jail. But, you know, he moved to Florida, he had a nice house, and he was living well. That's because under Florida law, his house, no matter what the size, what the value, is exempt from the claims of creditors. These same rules apply in Texas, they apply in Kansas. I don't know where else they apply, but you know, you can have a house of any value. You can have a farm, you can have a mansion. O.J. Simpson's, most of his wealth came from his 401k and his retirement plan through the NFL, the National Football League. And those plans are qualified under ERISA, and those plans are exempt from the claims of creditors as long as you keep the money in that plan. Some states also say that your IRA is completely exempt from exemption. Kansas, Florida, Texas, I think Nevada. California does not. California has some limitations on it. California allows you to keep not very much equity in your house. $75,000 if you're single, $100,000 if you're married, $175,000 if you're over 65. And you may say, well, where can you get a house for that kind of thing? Well, you can do it in needles or weed. Otherwise, it gives you a nice down payment on your house. And you can keep a car, you can keep your household furnishings, and you can have $9,700 cash value in a life insurance policy. Now, what things that bankruptcy attorneys do is we do something called exemption planning. And so if somebody comes and they are in financial trouble, you can take a look at what they own and try and convert some of their non-exempt property, like the money in the bank, into exempt property. You know, maybe you pay down the mortgage on your house a little bit while you're still within kind of the exemption level, or you buy the life insurance policy, and a husband and wife can shield not quite $20,000, so you have $20,000 cash value in the life insurance policy. You can buy a funeral plot, you can spend some money improving your home, maybe you can buy an annuity based upon the rules. And there is case law that specifically says that exemption planning is not a fraudulent conveyance. It's allowed. It's something that you can do. And so if a client comes to you in financial trouble, it's time to sit down with the bankruptcy lawyer about exemption planning. But I will give you one proviso, is that the cases are kind of across the board, and you just want to remember that pigs get fat, hogs get slaughtered. And if you can read the cases where people were really aggressive about exemption planning, and those people tend to lose their bankruptcy discharges, the exemption planning tends to get put aside. So it's a very fine line to walk. Okay, next slide, please. Another way of doing asset protection planning is entity planning. And so the way you own your stuff can shield you and can shield those assets. You know, and the classic one is just setting up a corporation. And of course, for Brenda and me, you know, we can create a corporation. It doesn't do us any good because we're still on the hook anyway. But if you own a hardware store or something like that, and you own your hardware store in the name of your corporation, theoretically, you are not personally responsible for the debts of the hardware store or the claims arising from your operation of the hardware store. If somebody's walking down the aisle and something falls off the top shelf and hits them on the head, you personally are not supposed to be responsible for that. Now, I could spend days talking about piercing the corporate veil. I won't. But anyway, that's a classic version of entity planning. We now have limited liability companies, which also provide us with some exemption, some entity planning. And in some ways, it provides more protection than corporate planning because some states are selling selling their laws, basically, provide very debtor-friendly planning for a limited liability company. And if a claim arises from the operation of a limited liability, the creditor can only look to those assets inside the limited liability company. If you have a claim against you, a creditor can seek to get your corporate stock. So Richard, you know, I can get the Richard Musio Inc. stock. But if it's Richard Musio LLC, theoretically, I'm only entitled to a charging order, which means that I'm only entitled to the income that comes out of the corporation or of the LLC. And if Richard is running the LLC, how much income do you think is going to come out of it? Probably not, right? So it's a little bit more protection. You can create a trust. In fact, most trusts probably have this provision. It's called a spendthrift clause. And you can create a trust that says the assets in this trust are not subject to the claims of creditors. And in California, if you create a trust for somebody and it has spendthrift provisions for the beneficiary, those provisions are effective. So, Terry, I create a trust for your benefit. And I say, Terry's a good guy, but he needs to show a little bit more maturity and not spend so much money. And so we're going to have a different trustee. And if Terry gets in financial trouble, those assets are not subject to the claims of his creditors. His creditors can't reach them. Those are effective under California law, and they're effective under the bankruptcy laws as well. I can't do that for myself in California. I cannot create the Jan Copley Irrevocable Trust and it says this is not subject to the claims of my creditors. However, I can do that in some other states. Nevada, Alaska, Delaware, there's some other states that basically say if I create an irrevocable trust for myself and the trust says that these assets are for my benefit and my creditors can't reach them, it is effective in those states. Now you generally have to have a trustee cited in that state. So in Alaska, the statute was written by the brother of the fellow who owns the Alaska Trust Company. You know, there's some stuff that goes with this. I'm not making this up. But it is a way of protecting yourself. Whether or not these are effective is another story. It goes to constitutional law. But let's say you're a creditor and you bump up against Jan Copley, who's created this Alaska Protection Trust for herself. And I have to move my judgment to Alaska, talk to the Alaska trustee, have the Alaska trustee say, no, sorry, no way, Jose, file a challenge to that in the federal court in Alaska. Am I going to do it? No. I'm just going to say, all right, Jan, pay me 50 cents on the dollar. I'm going away. Yes, sir.
Okay, so if you have a property, say domiciled outside one of those states, and you wish to put it into the trust, if there is a encumbrance on that property, don't you have to notify the lender and they would have approval rights to accelerate the loan?
The question is what if I have real property with a lien against it and I want to put the property into one of these irrevocable trusts? Will the lender call the loan? And I have to give you the lawyer answer, which is it depends. It depends upon the lender. It depends upon their perspective. I mean, if you've got a loan with a lender and you're paying 8%, they're probably not going to call the loan. The other thing is that if it's a personal residence, if it's small, there's no particular thing on it. But on the other hand, that's something to think about if you're transferring property to the LLC or the irrevocable trust or those kinds of things. So then finally, you can do offshore planning. You can do planning in the Cook Islands or the Isle of Man. And basically, those countries say, yeah, fine, you've got a judgment against you. We don't recognize California law. And you can have this stuff here, but you have a trustee in the Cook Islands who's managing your stuff. And basically, somebody gets a judgment against you and tries to get the assets that are held inside the Cook Islands Trust. The trustee says, sorry, we don't recognize judgments. And there's one very famous case where somebody did that, and they were involved in a Ponzi scheme, and the Federal Trade Commission got a judgment against them, and they couldn't get at the assets in the Cook Islands. And the debtors wound up in jail for contempt of court, but the FTC never did get their stuff, and after a couple of years, the debtors got out of jail. Now, it's your decision about how much you want to risk this. Yeah, how much you want to risk this, but can you see the kind of leverage you get with that kind of things? And so when I teach asset protection on a visual level, and maybe you want to flip your page over, you can write asset. And then you can draw a box around it that's exemption. And then you can draw a box around it that says limited liability company. And then you can draw a box around it that's a domestic asset protection trust. And then you can draw a box around it that says offshore trust. And for some people, this kind of planning is useful. It's especially works, say, if you've got somebody that sold a business, because very often the people who buy the business can't do it and they blame it's all on the seller. And in the meantime, the seller has retired to Costa Rica and they really need this money to retire on. You like that. The domestic asset protection trust and the offshore trust planning is a good way of shielding them. So let's go next to retirement plan basics. So that's your asset protection primer. Do not do this at home. I've just given you the very, very most basic ideas, but it's an idea to give you the concept. Retirement plans, you're familiar with ERISA plans, you're familiar with IRAs, you're familiar with required minimum distributions, you're familiar with the concept of stretch outs. I just put this up there because it all sort of blends in within the context of asset protection planning. One problem with asset protection planning for retirement benefits is only people can own them. You can't put them in the LLC or the domestic asset protection. Well, maybe you can do it in the domestic asset protection trust. We'll get to that in a minute. But you can own the IRA. You can also have a trusteed IRA. And this is something that was really cool for me to learn about is if you have a trust that is a grantor trust, and this is a technical term, and Brenda and I can spend some time opining upon it after class, but basically the trust is invisible for income tax purposes. You run it under your Social Security number. And if you are the sole beneficiary of your trust, that trust can own your IRA. It is not deemed to be a withdrawal. You can still take the required minimum distributions based upon your life expectancy. Now, I have to say that this theory works on a legal level. The IRS and some PLRs, private letter rulings, have blessed these, especially for people who have inherited IRAs and created a trust to own their inherited IRA. There's a couple of other private letter rulings that aren't quite so clear. But the theory is you can set up a trust to be the owner of your retirement account. And I like this concept, not just for the asset protection planning concepts, but one of the problems that Brenda and Brad and I find with estate planning is people have the $2 million retirement account. They have the $2 million IRA. And we can't put it in their living trust, or we may not be able to put it in their living trust because the living trust says these assets are available for the benefit of my spouse, my kids, whatever, as well as me, and so you can't do that. But the other thing is that, and so if the plan participant gets sick, the assets are managed pursuant to the terms of a power of attorney. And a financial institution, a trustee, institutional trustee is perfectly happy to be trustee of the trust during incapacity, but they're not willing to be the agent under the power of attorney. Well, one reason you may have named the institutional trustee is because you don't trust anybody around you, but who are you going to name as your agent under the power of attorney if the institutional trustee is not going to work? And so I think in certain instances, this might be something very worthwhile to look at. For the elderly person who's alone, for the people who don't trust their kids, that kind of stuff. I want to say, because I run into this daily, it is the bane of my existence, and if I'm insulting you, please let me know. But I am always told by financial institutions, no, you can't name a trust as a beneficiary of an IRA. You can, and sometimes it's a good idea. There are 5 aspects to this. A trust has to be valid under state law. And I got to tell you, if you can't get your trust valid under California law, you have no business being anywhere. It is so easy, and if you want to check with me the statute after class, let me know. It has to be irrevocable on the participant's death. Well, that's sort of a no-brainer. That's what trusts are. The beneficiaries have to be identifiable. And so that doesn't mean I name Terry, I name Richard, I name Len, I name Albert as my beneficiaries. You can say my issue. And when you die, people will know who your issue are. They will know your kids, your grandkids, whatever. So you don't have to be specific by name. You have to provide certain documents to the plan administrator. Basically, that means that you have to provide a copy of the living trust to the plan administrator by October 31st of the year following the year of your death. You can do some shortcuts, but that's the easy thing to remember. And then finally, all beneficiaries are individual. You're all familiar with the concept that you cannot have a designated beneficiary if that person is your estate, if that person is a charity, if that person is the state for whom you're paying taxes. But if you do the plan, if you draft the trust, or if Brenda and I and Brad draft the trust appropriately, the trust can be the beneficiary and the assets can flow through. Now, why would you do that? How many of you know 19-year-olds who aren't particularly good at managing their money? I did this yesterday afternoon. I created some separate standalone retirement plan trusts for some clients. And they have a son, and son is a responsible fireman. Son has a 5-year-old. They like his wife well enough, but they're tired of being an ATM for their son. And they have some concerns about son's wife's family's visions of money. And he has about $1.5 million IRA, and he wants that to be a safety net for his son. And so what we've done is provided that the assets are held in trust for the benefit of son. He sees the required minimum distributions based upon his life expectancy, because you can get the stretch out if you flow it through a trust, and that somebody else is the trustee until son turns 50. And so that way they're preserving the wealth, they're making sure somebody else is controlling it. And this means that son's wife's family can't get at it because it's held in trust. It means that if son and his wife break up, wife can't call that community property. It means if son gets in some kind of financial trouble, creditors can't get at it. If son inherits the IRA outright, you may not have those protections. Son can go down to the bank and say, I want it all, gimme. And so much for the safety net, right? Son might then roll it over into the joint bank account, and then wife says, I'm tired of living with you. Half of that is mine. And if that's one problem with naming somebody individually as the beneficiary of a retirement account, you have none of the structures and controls that many, many people want for protecting their wealth throughout their bloodline for other purposes. Now, under California law, your public retirement benefits are exempt, period, end of story. So if you have, a 403B or a pension plan through CalPERS or something, those assets are exempt, end of story. Your 401k, your defined benefit plan under ERISA are exempt under the ERISA rules. If you have an IRA or a private retirement plan, those are only exempt to the extent necessary for your support and your family support upon your retirement. And so my client with the $1.5 million IRA, if he were in bankruptcy, he would probably see some of that go to the bankruptcy trustee. These people are in their 60s, and they may say, well, you're going to have to sell a couple of your houses, and your lifestyle is going to be a little bit more modest, but some of that would go. And you may say, yeah, but I've heard that in bankruptcy you have this $1 million exemption, but not in California. That's a federal exemption, and California has opted out of it. So there are some real restrictions on protection of your retirement account. You can maybe use some of the money for other exempt property, and maybe you want to, there are some laws, and it's complicated, I'm only going to touch on it. If you can trace the money in your IRA that came from another exempt account, like you rolled over your 401k or your pension plan into an IRA, if you can trace it, that might be exempt. There's a California case that says that. So anyway, that's asset protection planning for the plan participant. And so if you're working with somebody who is looking to retire, and it's really important that they keep all of this, they need this, or you see a problem on the horizon with maybe protection, the easiest way to protect it is to keep it in the ERISA plan, but that way you may not get control of it. You certainly don't have the flexibility under the company 401k that you do with the retirement account. But you might want to be very careful that you don't roll this IRA money into the other IRA that they put together with their $2,000 a year that they went to the bank and got the toaster from. You might want to set it separately. So that's the first step of asset protection for the plan participant. The other thing is, somebody's really looking like they're in trouble, tell them to move. Move to Texas, move to Kansas, move to Florida. Maybe it's protected there. There are some statutes that say that you have, if you do this and then you filed for bankruptcy, you have to have lived in that state for 10 years. So this is when somebody owns the apartment building, you say, you know, let's move to Florida now. One other thing is I kind of like the idea, I haven't experimented with this and I don't know if it'll work and I haven't read any cases, but remember I was talking about the trust deed IRA? What if you created a trust deed IRA with the domestic asset protection planning stuff in it? What if you created the trust to own your IRA that is exempt from the claims of creditors under Delaware or Alaska law? And you're going to have to file a plan custodian who's willing to do it, but I bet the Alaska Trust Company would. But that might be another way of protecting wealth and protecting your client. So that's asset protection planning for the plan participant. Asset protection planning for the beneficiary goes through trust planning, which is what asset protection people do for beneficiaries. So like I said, I've already riffed on this, that if you name your kid as the beneficiary, it goes to them outright and there's basically no protection for them. You can have an inherited IRA and it's easy. You know, the IRA is set up as Jan deceased for the benefit. Who haven't I picked on here? Elizabeth. So Elizabeth, you just inherited, you know, I don't know, a couple $100,000. It's not going to change your lifestyle, but it's something that would be tempting to the 19-year-old. You, of course, would be responsible and deal with it. But, you know, an inherited IRA, you know, the IRA may be exempt for the plan participant, but the case law is really quite contradictory as if that exemption applies to an inherited IRA. So let's say I live in Florida, I have an IRA, it's exempt, it's completely exempt from the claims of my creditors, I die, I leave it to Elizabeth. Well, Elizabeth didn't earn that money, and that's not really earned by Elizabeth for the purpose of her retirement. It's kind of a windfall. That may or may not be exempt. The cases are going both ways on that one. So I would not rely upon this inherited IRA as being exempt. So at that point, what you may want to do is leave the IRA in trust for the benefit of Elizabeth or Brenda or Albert or whomever. I can't read your tag. Anyway, everybody here wants to inherit my IRA. So there are two ways to leave your wealth in trust for a beneficiary, because just because somebody has inherited your IRA doesn't mean that's the only discussion. I already walked you through the 5 things that you have to have in the trust in order for the trust to qualify as a designated beneficiary. But how the trust is set up upon your death affects how the distributions are handled to the beneficiaries and the extent of the asset protection. The first one is called a conduit trust. And remember, I was talking to you about this husband and wife who were creating the trust for the benefit of their son, and they want the son to get the required minimum distributions based upon his life expectancy to be distributed out of the trust every year to son. That is a classic conduit trust. The distributions are distributed to the beneficiary. If you have multiple beneficiaries, the stretch out is based upon the oldest beneficiary's lives. You can do some things in your beneficiary designations to fix this, but that's another hour-long presentation. And to the extent the assets are held inside the trust for the benefit of the beneficiary and the trust has a spendthrift clause, those assets are not subject to the claims of the beneficiary's creditors. However, the minute the money comes out, creditors can get it. So in my particular case, son, you know, he's 36. So what is he going to get? Like 1/60th right now, you know? And so if that 1/60th of dad's retirement account is distributed to his bank account and a creditor can glom onto it, not that big a deal. But what if son is 60? It's a much bigger distribution. And the minute it comes out, it's subject to the claims of creditors. And under a conduit trust, it has to come out. And so in this particular case, mom and dad are more, I think, concerned about their daughter-in-law's family than they are son's creditor stuff. And they want this money available for a safety net for son and for their granddaughter. Well, incidentally, daughter-in-law is going to benefit from them. So this works for them. But another problem with the conduit trust planning is, let's say your beneficiary is a special needs beneficiary. You know, they qualify for, they have a disability. They qualify for disability. They qualify for Medi-Cal benefits. You set this stuff up in a conduit trust. The required minimum distribution is paid to the beneficiary. You may have just disqualified them from public benefits. And you say, okay, cool, fine, you know, that's fine. You know, we really want to support people, and public benefits don't provide people with great lifestyles anyway. But at least through the end of this year, you've also disqualified them from health insurance. I don't know how the Affordable Care Act is going to affect this kind of thinking, but very often it is hugely important to keep somebody on disability, if only for those reasons, to keep them on Medi-Cal. And so naming a special needs beneficiary, a special needs child, or a special needs person as the outright beneficiary of a retirement account or the beneficiary of a conduit trust is probably not going to accomplish what you want it to do. Brad, you agree with me on that one? Not here, not talking. Okay. The other thing that you can do is an accumulation trust. An accumulation trust is a trust where the retirement account pays the required minimum distributions based upon the beneficiary's life expectancy to the trustee, but the trustee holds on to them rather than passing it outright to the beneficiary. And so that way, rather than the beneficiary getting these ever-increasing required minimum distributions, distributions are made to the beneficiary based upon traditional trust planning structure, you know, health, education, maintenance, and support, maintaining your lifestyle. If they're a special needs person, you know, enhancing their life based above what the public benefits buy, you know, buying the flat screen TV, maybe paying for the private room in the convalescent facility. Once again, the stretch out's only on the oldest beneficiaries. The required minimum distributions are retained in trust. As long as they're retained in trust, creditors can't get at the stuff. The state can't get at the stuff, you know, for special needs planning. And you have a lot more asset protection planning. And you may be saying, why in heaven's name would anybody do anything other than an accumulation trust? And there's really two reasons. Is that the first one is trust rates for income taxes tend to be much higher than trust rates for individuals. Now, if somebody's a special needs person, they're not earning a whole lot of money, maybe that's an especially a consideration. But, you know, trust rates go up to the maximum. Who's the CPAs in this room? It's like $12,000 or something like that. It's amazing, and it suddenly is taxed at the federal rate of 35%. Whereas if the assets are, the required minimum distributions are passed out to the beneficiary, you're probably going to have lower income tax rates. The other problem is it's really hard with you have to be very, very, very careful with an accumulation trust to make sure that you don't have a beneficiary down the line who's going to disqualify the retirement account from being a designated beneficiary. And remember I said the designated beneficiary can't be your state, can't be used to pay taxes, can't be a charity, something like that. And with a conduit trust, the IRS says, yeah, you know, it's going to them, they're the beneficiary, we can determine the oldest lifestyle, good. But with an accumulation trust, you have to take a look at who the first beneficiary is in trust, and then who might inherit it from then, until you find the last person, and that has to be a human beating heart. It can't be your cat, it can't be the American Cancer Society, who will inherit that money. And if it is your cat, if it is the American Cancer Society, the whole thing, you know, all the retirement benefits have to be paid within 5 years, pay all the taxes. And if for some reason or another one of those people potentially is older than your beneficiary, the required minimum distributions are based upon the life expectancy of the oldest beneficiary. So I have a trust and I say, you know, my husband's older than I am. He's got enough money. Fine, we'll take it out of there. And so I leave this to my issue. Well, my issue are by definition younger than me. But if I adopt somebody, I could go nuts and adopt somebody, older, and the required minimum distributions would be based upon their life expectancy. Or if I leave it to my heirs, well, after my husband, my next heir is my 88-year-old mother. And so you have to be very, very careful about naming this. I think the thing is this is a very good concept to talk to your clients about, especially if they're worried about their children, especially if they're worried about their wealth. But don't do the beneficiary designation without at least consulting with somebody who has some expertise in this area. And so as for the wrap up, the moral of the story is this stuff isn't easy. Every time I delve into retirement benefits, I sit there and I think, who made this stuff up? It's crazy. And why should it matter if you die if you're 70 and 6 months and 10 days versus 70 and 5 months and 29 days? And why should it matter if it's a conduit trust or an accumulation trust? Or why should it matter that the life expectancy is based upon my mother's life expectancy when it's just so unlikely to happen? But nobody asked me when they put together the rules, and those are the rules that we have to put together. I think the other, on the other hand, it ain't easy, but it may very well be worth it. And I'm hoping that if nothing else, today's presentation opens up some ideas to you about some additional planning that you can do to help your clients and when it might be worth it. Another thing is something else might be simpler. Let's say you have 3 kids, one's a special needs child, and the other 2 are responsible people. Maybe you don't want to make that special needs child the beneficiary of the retirement accounts at all. Maybe you use your required minimum distributions to fund the life insurance policy in the special needs trust for your child. Because then you don't have all this required minimum distribution, and does it qualify as an accumulation trust, and do all of this other kinds of things. And it might be better for you. Your clients will appreciate the simplicity, and you might make a little bit of a premium on it. So that's not such a bad thing either. But the moral of the story is that if you do it right, it can be done. Now, I've zapped through what could very much be like 2 days of legal education. I've tried to avoid the lawyer problem of telling everybody everything I know and then just scaring them to death. I brought printouts of the California exemption statutes, the appropriate case law, a whole mess of stuff. I can talk to you about those detailed questions, but does anybody have any questions for me from today's presentation? Yes, sir.
I just want to know about the look-back period when you're trying to protect these assets.
Uh-huh.
Is there not a look-back period of years or?
Is there a look-back period if you're doing exemption planning? And, well, I'll run you through some statutes. If you create a domestic asset protection trust, and you file for bankruptcy, your trustee can look back 10 years. And so, and actually there's a case that came out like this month where somebody created the Alaska Asset Protection Trust. And everything was copacetic when they did it, but they've since got into financial trouble, and it's only been 6 or 7 or 8 years. The bankruptcy court said, it's all coming back into the estate. The statute for fraudulent conveyance laws in California is 4 years from the date of discovery of the transfer, because generally people don't broadcast these transfers when they do them, or 7 years from the date of the transfer, whichever is, but no later than 7 years. So in California, if you're not doing asset protection planning, it's 7 years. With exemption planning, where I talked about, you turn the unexempt asset into the exempt asset, there's no particular bright line, but the longer it is, the better it looks, and it also, there's a whole totality of the circumstances kind of deal. And so let's say your client they're getting in financial trouble, and you decide to set up a private retirement account for them, or they suddenly set up the 401k in the business that they've run for 25 years and they've never had one before. And they do that, and then 2 weeks later they file for bankruptcy. trustee's likely to say, And if your creditor is really kind of upset with you, they're likely to say no. But if you set up the 401k a year ago and funded it as much as you can, that's probably not a problem. So I'm sorry I have to give you the lawyer answer, which it depends, but I'm hoping that this is a little bit useful to you. Yes, sir. You got your hand up first.
Life insurance in California, is it an exempt asset?
Is life insurance in California an exempt asset? And it's exempt up to, let me look it up so I can give you the exact figure. It's exempt up to, where to go? I have to do this because I wrote it down. It's exempt up to $9,700 of the cash value, and a husband and wife can shield $19,400. The the death benefit, a creditor can't reach. But if you have cash value of $200,000 in your policy, yes, a creditor can get at that. You had a question.
Yeah, you mentioned that under the accumulation trust, there's a potential problem with the RMD because the RMD is based on the oldest person's life expectancy. So the question is, can you have two trusts for break it up?
The question is, can you have two trusts? You can have one accumulation trust, and so you'll take the risk that maybe my heir will be my 88-year-old mother and I don't much care. And can I set up a separate trust as a conduit trust for my special needs child? And the answer is absolutely yes. And so maybe your beneficiary designation says that 50% of my retirement account goes to the conduit trust created for the benefit of my doing well adult children, and the other 50% goes into the trust for the benefit of my special needs child. Yes, you can do that.
And I set up a trust for each one of my beneficiaries so everybody can use their own age?
And the question is, can I set up a trust for each of my beneficiaries so each of them can use their own age? The answer is yes. Another way of doing it is I create the Jan Copley Standalone Retirement Plan Trust, and I've got one trust for the benefit of my husband, one trust for the benefit of my 40-year-old stepson, and another for the benefit of my 45-year-old stepson. My beneficiary designation can say a third to my husband, a third to my stepson, a third to my stepdaughter. And they should be able to each take their own life expectancy. But you can't just do the beneficiary designation saying I leave everything to the Jan Copley Trust. That tends to mess stuff up. It requires a little bit more than mindlessly filling out the form, which I'm sure none of you have ever done, but some other people do it. So, okay, well, I hope, one more question, and then I think I get yanked off the stage.
So you mentioned that the RMDs in the conduit trust would be subject to creditors. What about other distributions that were then made from the IRA?
And the question is, if we make distributions from the IRA other than the required minimum distributions, are they subject to claims of creditors? Anything that winds up in the trust beneficiary's personal bank account, subject to the claims of their creditors. Okay, I hope it's been useful. If you have more questions, see me after class. Like I say, I came way over prepared. I want to thank Brenda for the opportunity to do this because it means I'm feeling much more confident about these rules than I was before I tackled the project. Also, if I can be of assistance to you, please let me know. Okay, thanks.